The late fall of 1858 was one of jubilation for the town of Oberlin and for other towns across the North. The rescue of runaway slave John Price from slave catchers who had tried to kidnap him in the free state of Ohio had drawn national attention. Price had escaped, probably to Canada. The rescuers, mostly students and faculty from Oberlin College and white and black Oberlin townsmen, were heroes for the growing number of people who regarded the federal government's fugitive slave law as not only an injustice to runaway slaves yearning for freedom, but for otherwise law-abiding citizens in general who sympathized with them.
The fugitive slave law caused so much resentment, especially in the North, that it might have actually swayed more people against slavery than ever before. And it led to a showdown here in northeastern Ohio, one of the biggest legal showdowns in United States history.
The President of the United States in 1858 was James Buchanan. He was determined to enforce the fugitive slave law with all the power of the federal government. Buchanan dispatched federal lawmen to Ohio to arrest the Oberlin rescuers. One by one, the people involved in the rescue found themselves rounded up and thrown in jail. Federal Marshal Matthew Johnson went first to the home of Oberlin Professor Henry Peck, who greeted the marshal with courtesy, accepted the warrant for his own arrest, and even helpfully led the marshal through the streets of Oberlin so he could track down the others involved in the rescue. James Fitch marched into prison while giving instructions for someone to cover for him at the Sunday school where he taught, and was much loved by his young pupils. While he was in prison, he would receive hundreds of letters of support from the children.
Some of those arrested found that their names had been misspelled on their warrants. They helpfully corrected the officers and gave themselves up.
William Lincoln, who had a major role in spiriting away the fugitive slave John Price, was tracked down and arrested while teaching a class in Dublin, Ohio. Two men waving pistols barged into the schoolhouse and clapped Lincoln in handcuffs in front of his horrified students. One of the men explained to the children that Lincoln was a bad man. One tearful girl exclaimed, "There's more goodness in his little finger than in your whole carcass."
It was one thing to go after the, quote, religious fanatics, as the plain dealer called them. But then they started to go after farmers and shopkeepers, ordinary folk. That made the matter more personal. 8 of the 12 initially indicted for the rescue of John Price were from Wellington, Ohio, leaders in the community who had never been in trouble with the law before. Loring Wadsworth had just been elected mayor of the town when he was arrested. Almost half of the men from Wellington were over 58 years of age. Farmer Matthew Gillett, age 71 and nicknamed Father Gillett, was the oldest of the group. Crowds cheered in support for them as they were led away.
Ultimately, 37 rescuers were indicted, though 7 of them were never apprehended. 3 of them, John Hartwell, Jerry Fox, and Thomas Jenna, had been runaway slaves themselves and were shy of appearing in a public court, even in a state which had given them sanctuary. One key figure in the rescue who escaped indictment was John Copeland, who was rumored to have escorted John Price to Canada. Another Freeman rescuer who evaded the law was Lewis Leary. Both Copeland and Leary would later die, serving with John Brown in the raid on Harper's Ferry in 1859.
Oh boy, the backlash from the arrest was hot. Not just in Wellington, but all over Lorain County. People were mad at the federal government. U.S. Deputy Marshal Anson Dayton was so harassed by people for his help in the arrest of John Price that he fled the town with his family. Lorain County lawmen served up an indictment against the slave catchers for kidnapping. Anderson Jennings and his band would find themselves defendants in county court at the exact same time they were testifying against the rescuers in federal court.
This court is called to order.
On Tuesday, April 5th, 1859, the case of the United States versus Simeon Bushnell, the first of the rescuers to be tried, began. Judge Hiram Wilson, a Democrat and sympathizer with the Buchanan administration, presided. The lead prosecuting attorney, George W. Belden of Canton, had once been opposed to the Fugitive Slave Act, but now was an ardent Democrat and strict proponent of enforcing the act.
Selecting lawyers to defend the rescuers was a hard choice. Just about the entire membership of the Cleveland Bar Association wanted to be on the defense team. Those selected were the cream of the Cleveland legal scene.
The rescuers had selected 3 Cleveland lawyers who had volunteered to defend them. Heading the defense was 60-year-old Rufus Payne Spaulding, a former Speaker of the Ohio House of Representatives, friend of then Ohio Governor Salmon P. Chase, and, though a Democrat, much against slavery. Albert Gallatin Riddle, 42 years old, another friend of the governor and a bitter foe of slavery, and young Seneca O. Griswold, 32, who had been an Oberlin graduate, assisted Spaulding.
It was a snowy, nasty day, unseasonably cold for Cleveland in April. Even so, the courtroom was packed. Prosecutors, defense attorneys, 17 of the rescuers and their friends, wives, and other relatives. Many of the women were knitting as they sat there. Then also there were reporters, crowds of them, from newspapers and periodicals locally and from around the country. One of the reporters, John Cagey, from the New York Tribune, was a follower of John Brown and was in town to cover the trial and to raise funds that would later be used for Brown's raid on Harper's Ferry, in which Cagey himself participated and gave his life for as Brown's second in command. But the character that made the biggest difference in the whole affair was the presiding judge, Justice Hiram V. Wilson, staunch Democrat, Buchanan man. He was all set to throw the book at these anti-slave fanatics as he saw them.
Mr. Bushnell, you are on trial here for violation of federal law, specifically obstructing the lawful repatriation of fugitive property, one John Price, chattel slave of Mr. John Bacon of Kentucky. Counsels will proceed with jury selection.
From the very beginning, it was clear Judge Wilson was not going to give the defense a fair hearing. He had Court Clerk Green, another pro-slavery Democrat, call only the few Democrats that were in the jury pool, ignoring the names of any Republicans on that list. In other words, the jury would be packed with pro-slavery Democrats.
The first witness on the stand was the slave owner from Kentucky, John Bacon, there to prove that John Price was indeed Bacon's property.
My property, John Price, about 5'6" or 8", heavy set, 104 pounds or so, copper colored.
This would be a huge point of contention. Nobody seemed to agree on what John Price looked like. Certainly, most people contradicted Bacon, the actual owner of John Price.
Mr. Ralph Peck, professor at Oberlin.
Yes, sir.
You know John Price the runaway?
I know John Price the man.
Describe him.
Short, maybe 5'5", black, not copper-colored, decidedly black.
Then there was another problem that arose about the jury.
Mr. Riddle, you wish to make an objection for the defense?
Yes, Your Honor. The defense has found out one of the jurors is a deputy marshal. I am sure I don't need to remind this court that officers of justice are forbidden to serve on juries.
That is correct, Mr. Riddle. You do not need to remind this court about anything.
The defense urges the court to replace this juror.
The court has taken note of the fact.
You will disqualify this juror.
I will not.
But, Your Honor.
I have taken note. Sit down.
After scores of prosecution and defense witnesses had testified, closing statements on the trial of Simeon Bushnell were made on the afternoon, April 11th, the 7th day of the trial. The accused rescuers all this time had been housed in the nearby Cuyahoga County Jail, awaiting their own trials under the sympathetic eye of County Sheriff David Whiteman.
Whiteman and the other jailers tried to make the rescuers stay in the jail as comfortable as possible. Not an easy task in a building infested with rats and with murderers and robbers as inmates. The rescuers spend their time praying, receiving hundreds of visitors, and even starting businesses making shoes and writing essays for magazines, and even printing their own newspaper.
The court rejects defense counsel's request that they be allowed to make 3 closing statements. Both sides will get 2.
Thank you, Your Honor. Gentlemen of the jury, John Price is clearly a slave. Bacon swears he was his slave and that he knew John's mother, and the maternity establishes the status as a slave or free man. Jennings and the other federal deputies involved in his recapture knew he was a slave. This evidence is not contradicted in any way.
The speeches on both sides went on for hours. All told, closing arguments lasted 3 days. Nevertheless, the court was packed. In fact, the marshals had to make sure there were seats reserved. Reserved seats for women took up the whole east wall of the courtroom and were filled immediately. The overflow of people was so great they opened the door to the adjoining judge's chamber and put chairs in there. The lawyers knew they were not just addressing the jury, they were addressing the nation.
These men who outraged Jennings and his men, who were acting legally under power of attorney to recover the fugitive slave John Price, they went down to Wellington, proclaiming that they did so under the higher law, for they knew they were outraging the law of the land. Now all of these self-styled guardians of a higher law in Oberlin are having a good laugh over this. This is thought to be a good joke. People around Oberlin think so little of their government and statutes of the federal government when they interfere with their sympathies with Negro women and men that they consider their violation a joke. It is not a joke. It is contempt for the United States. It is treason. They must be made an example of so this sort of thing never happens again.
Order! Mr. Riddle for the defense.
Your Honor, we do not dispute the role of Simeon Bushnell in this affair. He and his associates knew John was a slave. Nevertheless, they put forth strong hands and, wrenching John from the grasp of his captors, consigned him to the boundless realm of freedom.
Order!
The prosecutor sneers at the rescuers' answer to a higher law than this federal slave law, while I am perfectly frank to declare I too am the votary of that higher law.
Order! Order! Order in the court!
Now, I and everyone here know that the Fugitive Slave Act is here held as law, that the decision of this court is to add another scale to that great scab that deforms and debauches American jurisprudence. But it shall never be recognized and accepted by our people as law. Never, never.
Your Honor, order, please. These court disruptions have to end. It is an affront to this court and brings dishonor to the pursuit of justice. These people should be taken into custody.
Be careful, sir. Some of those distributors are members of the Bar Association.
Well, sir, you and they can leave with the rest of them.
Order! Order! Mr. Belden is right. I will clear this courtroom if need be.
Let us talk about this fugitive slave law. I believe His Honor himself, Judge Wilson, signed a petition in 1850 calling the law unconstitutional. I hear Southerners scream that Congress has no authority to enact laws that infringe on states' rights. Well, we here in Ohio say the same thing. The United States Congress, the United States Supreme Court are in a lockhold by the slave-owning...
Objection! Established federal law is not on trial here, Mr. Spaulding. This man, Simeon Bushnell, is interfering with lawful reinstatement of runaway property to its rightful owner.
It's. God forgive me if I ever refer to another human being as it. Is it not important that we ask whether the time will not soon be upon us when our children should be called it? That our own children shall have the manacles now brought from Kentucky for African slaves encircling their fair limbs? But we are told that there is no danger of mistaking Saxon children for African slaves. I am pointing now to this flaxen-haired little boy here in the audience.
This had been planned by the defense team at the very beginning, bringing in this light-skinned boy to sit in the courtroom.
Gentlemen of the jury, is there one of you who would not be proud to recon this fair, blonde young man among your children? His skin is whiter than the district attorney's, and his hair not half so curly. And yet, less than 6 months ago, that child was set free in the probate court in this city, having been brought a slave from North Carolina.
Objection! Objection! Are we in a dream? Are we in a court of justice? Or are we in a political hustings? This man's identification of a former slave boy is the most disgraceful scene I have ever witnessed in a court. And Judge Wilson has since gone on record to say the fugitive slave law is indeed constitutional. What the gentlemen and saints of Oberlin called higher law, Judge Wilson called devil's law, a doctrine that would make chaos and hell upon earth. Do you teach the Bible at Oberlin, or do you point out the spires of the church as hell portals?
Order! Order! Gentlemen of the jury, the constitutionality of the fugitive slave law is not a question for you to decide. Slavery is sanctioned by law in Kentucky. The slave John Price's status is not in question. The issue is simple. Was the defendant guilty or not guilty of helping a known fugitive slave to escape?
At 2 o'clock, the jury was excused to deliberate. At 2:15, they announced that they had agreed on a verdict.
We find the defendant Simeon Bushnell guilty.
Your Honor, the attorney of the people of these United States now brings suit against Charles Langston as accomplice to Mr. Bushnell in this case.
Very good. Please proceed.
Objection. Your Honor, the proper agreement between Mr. Belden and the defense was that Professor Henry Peck was to be the next defendant. This is the person we were prepared to defend. We're not ready
Your Honor, the prosecution must insist that colored malefactor Charles Langston be the next accused to stand trial.
Proceed with the prosecution of Mr. Langston.
But, Your Honor...
Your backroom dealings are of no interest to this court, Mr. Spaulding. Mr. Belden, you may proceed.
Your Honor, the defense once again insists that before proceeding with the case of Mr. Langston, we impanel a new jury.
The court has already ruled that the present jury will serve for all the defendants in this case.
Your Honor, the same jury?
Sit down, counselor. This court has already made that decision.
You mean to use this same jury, these same men who have sat through and upon this case heard all the testimony, and who have now, in the presence of this court, rendered a verdict in which their minds are made up and fixed upon all the important points in this case, are to be held competent to try another case almost exactly similar? This is unheard.
You are out of order, Mr. Griswold, and will be cited with contempt if you attempt another outburst. This is no occasion for excitement or intemperate zeal. This jury will decide each case based upon the evidence offered in that particular case.
The defense strenuously objects with this proceeding. The prosecution could call the accused up as fast as he please and try them, but the defense is under protest. We will call no witnesses for the defense, and we will not appear by attorney before such a jury.
Very well. The district attorney and the people of the United States ask the court to order these men into the custody of the marshal.
I second the motion.
The district attorney is entitled to the order. Let the accused be called.
And so, with Marshal Johnson and his deputies at their back, with guns ready, with Henry Peck chosen as the rescuers' spokesman, and recently elected Wellington Mayor Loring Wadsworth at their head, along with recently convicted Simeon Bushnell, who would be awaiting sentencing, they all marched off to jail. But here's the irony. Anderson Jennings and the other slave catchers involved were confined in the Cuyahoga County Courthouse for fear that they would be arrested by lawmen from Lorain County, where they had already been indicted in absentia of kidnapping for the same case. Indeed, Lorain County lawmen were sitting in the courtroom anticipating on doing just that, as the other rescuers were brought to trial and Jennings and other slave catchers gave their testimony.
The trials of all the rescuers would go on for another year. In that time, letters of sympathy and donations poured in from all over the country. A Quaker in Philadelphia sent $100, and a wealthy Cleveland man gave a donation that exceeded all but one of the many gifts the rescuers received while in prison, according to one account. Rescuer James Fitch's entire Sunday school class of 400 young students paid a visit, crowding into the prison halls and rooms, and later assembling in the yard to say prayers and read poems of support. Rescuer John Scott had started a printing press in the jail, and the first issue of his periodical, The Rescuer, over 5,000 copies, with articles written by several of the rescuers about abolitionist matters, was quickly distributed. It was to be the only issue. Soon after, the rescuers were tried and sentenced.
The trial turned out to be something of an embarrassment for the Buchanan administration, and Washington had urged the court in Cleveland to hurry up the proceedings, and so they did.
Only 2 rescuers faced trial. Simeon Bushnell, the first rescuer tried, had been sentenced to pay a fine of $600 and spend 60 days in jail. When he was released on July 11, 1859, he had been in jail 88 days, the longest of any of the rescuers. Charles Langston had been sentenced to $100 fine and 20 days in jail for the same offense. By that time, a settlement had been reached to free the rest of the rescuers in exchange for Lorain County dropping the kidnapping charges on the slave catchers.
Even that deal was in jeopardy at first. The Kentuckian slave catchers were fine with it. The only trouble was the rescuers refused the deal. Finally, they relented when the slave catchers signed an agreement never to hunt fugitives in northern Ohio again. That was an easy promise to keep for the slave catchers. They'd had their fill of northern Ohio.
In October of 1859, John Brown led a band of 18 abolitionists in a raid on the military arsenal at Harper's Ferry, Virginia, to try to start a slave insurrection. Though it failed, it sparked even greater hostility against slavery, which may have accelerated the move towards civil war. In the group were 2 of the Oberlin rescuers, Lewis Leary and John Copeland. Another Oberlin man was also in the group, a runaway slave from South Carolina named Shields Green, who also had been a servant to abolitionist Frederick Douglass. John Cagey, who had covered the trial for the New York Tribune, was also in the group. All would meet their deaths and be held up as martyrs in the cause of abolitionism. The rescuers would be touted as heroes in Oberlin and Wellington, and many demonstrations, parades, and feasts were held in their honor. In the years that followed, Abraham Lincoln would be elected and the country would be headed for civil war. One more of the rescuers did not live to see it. William Scrimger died of consumption in August of 1860, 1 year after graduating from Oberlin. The federal government was never able to collect the fine that Simeon Bushnell owed for the rescue. just 8 months after the outbreak of the war, he also had succumbed to consumption. He was 32. The remaining family was declared a poverty case and was exempt from paying off the fine. 4 other rescuers died during the Civil War, including Matthew Gillett in 1863 at age 77 and Wellington Mayor Loring Wadsworth in 1862 at age 62. Many Oberlin men served in the war, and at least 96 died fighting for the Union. 21 men from Oberlin joined the famous all-black Massachusetts 54th Infantry Regiment, the first of its kind in the war. John Langston, brother of rescuer Charles Langston, was a main recruiter for the regiment, as well as other later regiments, along with rescuer Orondatus Wall.
It is still a source of continuing pride. A major event in the history of northeastern Ohio, the rescue of John Price by residents of Oberlin and Wellington, Ohio. Old and young, black and white, students and professors collaborated there, sharing a common belief that the dignity of the human race abhors racism and slavery. It is an inspiration and influence on the region even today. Simeon Bushnell, the person who suffered the most from the legal repercussions of the rescue, reflects this pride, I think.
I ask no favors of the men who arrested me. They may do their worst, and when I'm out again, I will rescue the first slave I get a chance to rescue. I have sworn eternal enmity to the fugitive slave law, and while God lets me live, I mean to defy it and trample upon it. Never for one moment have I regretted the part I took in the Wellington rescue, and I hope none of you will, for we did right. We did our duty.